Preliminary Section 1 and 2. A proposal, when accepted, become a promise under Section 2B. Consideration for contract signifies a bargain element in a contract. Who among the following has no right to enforce a contract? A stranger to contract. Surendra dog is lost. He advertised in a newspaper. Anyone finds a dog will get a reward of 20,000. This advertisement is a proposal. An auction turned into a binding contract upon fall of the hammer. According to Section 2G of Indian Contract Act 1872, an agreement not enforceable by law is said to be void. Find out the correct response. Past consideration is no consideration. This statement is contract under English law of contract. Correct under English law of contract. The leading case of Carlyle versus Carbolic Smoke Ball Company is related to general offer. The doctrine of privity of contract means that only party to the contract can sue and sued upon the contract. Quid pro quo means something in return. Who is called the promisee according to the Contract Act? A person accepting the proposal. An executory consideration is mutual exchange of promise of one being a consideration for other. A notice in a newspaper inviting tender is an invitation to the proposal. In a contract, consideration could be supplied by even a stranger to the contract. Every promise and set of promises forming consideration for each other is an agreement. Which one of the following is correct? A contract may be oral. Two main completing definitions of contract in a common law are: contract is a promise or set of promise which the law will enforce, and contract is an agreement giving rise to the obligation which enforced to rise recognized by law. One of the basic principles of common law of contract is that the party of the contract are free to determine themselves and what primary obligation they will accept. Which one of the following constitute an offer? Advertisement announcing a reward of 5,000 to any person who would find the missing dog of the advisor. Which one of the following is explicitly stated in 2B of Indian Contract Act 1872? A proposal, when accepted, becomes a promise. In a case of general offer for a valid contract, the acceptor must have the knowledge of the offerer before accepting it. Acceptance by performance. The Indian Contract Act 1872 defined contract in the section 2H. Consideration means must have some value in the eye of law, must be real, must not be illusory. Past consideration is valid in India only. An agreement enforceable by law at the instant of one or more of the party and not of the other and others. Section 2I of Indian Contract Act is called voidable contract. Which judicial pronouncement of the Queen Bench of England has dealt with the concept of general offer. Carlyle versus Carbolic Smokeball Company. What is the terminology used to describe a situation when two parties making identical offer to each other in ignorance of each other's offer? Cross offer. Which one of the following is an exception to the rule of doctrine of privity of contract to the stranger? To a contract cannot sue. Family settlement. Privity of contract is that party to the contract can sue each other. Which one of the following ingredients is not necessary for the contract? Property. The preamble of Indian Contract Act 1872 states, where it is expedient to define and amend certain part of law relating to contract. Section 2D of Indian Contract Act say, when at the desire of promisor, the promisee or any other person has done or abstains from doing, or does or abstains from doing, or promises to do or abstain from doing something, such act or abstinence or promise is called consideration for the promise. Past consideration means the price paid or service rendered at the desire of promisor, followed by the subsequent promise. Exception of doctrine of privity of contract do not include equitable mortgage. The display of article in a showroom with a price amount to invitation to offer. Under the Indian Contract Act, a proposal when accepted become a promise under section 2B. Every promise and every set of promise forming consideration for each other is called an agreement. Consideration for a contract signifies the bargain element in the contract. The doctrine of privity of consideration means consideration may move from the promise or any other person. A proposal, when accepted, become a promise. Which one of the following is correct? Consideration can be past, present, or future. A proposal is defined under Section 2A of Indian Contract Act is willingness to do or abstain from doing any act in order to obtain assent or the other thereto. Which one of the following statement is correct? A voidable contract is an agreement which is enforceable by law at the option of one or more of the party thereto, but not at the option of the other and others. Which one of the following is not an offer? A bid at the auction sale. Interpretation clause of Indian Contract Act 1872 has been provided in Section 2. General offer open to world at large can be accepted by compiling with the conditions of the offer. Which one of the following is not essential for the consideration? Adequate. Every promise and every set of promise forming consideration for each other is an agreement. Which one of the following section of Indian Contract Act 1872 define consideration? 2D. A proposal when accepted become a promise. Union of India versus Madala Tithaya is an illustration where the tender was in form of standing offer. According to Section 2H of Indian Contract Act, a contract is an agreement enforceable by law. Which one of the following statement Consideration is not correct. Stranger to it cannot sue. A proposal, when accepted, becomes a promise. A consideration may be at past, present, and future. Every promise and every set of promise forming consideration for each other is an agreement. A proposal, when accepted, become a promise under Section 2B. Which one of the famous case is related with the general offer? Carlyle versus Carbolic Smoke Ball Company. The following rules as to the consideration is true. Must move at the desire of promiser. Indian Contract Act was enacted in the year 1872. A call up B and ask, will you sell me your house? SMS me the lowest cash price. B reply by SMS, lowest cash price for my house is rupee 1 crore. A immediately send another SMS to B stating, I agree to buy your house for rupees 1 crore as asked by you. B did not respond, subsequently sold the house to C. B's SMS was A2, an invitation to receive an offer. Difference between an offer and invitation to receive an offer is that an offer is definite without ambiguity, and an invitation to receive an offer is merely a statement with scope to further negotiation. An offer with accepted become a correct, whereas invitation to receive an offer can only lead to making an offer. The juristic concept of contract consists of offer and acceptance. Consider the following statement. According to Justice Patterson, consideration may be some benefit to the plaintiff and some detriment to the defendant. Consider the following statement. A shopkeeper catalog of price is not an offer. An auctioneer announcement that a specific good will be sold to the auction on certain day is not an offer to hold an auction. A promises to provide maintenance allowance to her maternal uncle in consideration of some property gifted to her by her mother. A refuses to pay maintenance amount and maternal uncle instituted a suit against A to enforce the promise. Which one of the following is correct statement? Maternal uncle will succeed because according to Indian Contract Act, consideration may be given by the promisee or any other person. What can catalog of book listing price of each book specifying the place where it is listed of book are available to be termed as an invitation to offer. A. Without the request of anybody, extinguish the fire of B's Godan. A. Suffer injury thereby. If B promises to compensate A for the whole amount he will spend for the treatment, then the contract is enforceable. A tender in the newspaper is an invitation to offer. An offer is a willingness to do or abstain from doing something with a view to obtaining assent of the addressee. In the formation of a contract, which is not an essential which is not among the three essential damages, an acceptance given by A on invitation for lunch over phone is not a contract because which one of the following? There is no intention to create a legal obligation. Which one of the following statement is correct? A void contract is an agreement which is enforceable by law at the time option one or more party thereto, but not at the option of other or others. An agreement not enforceable by law is said to be void contract. Choose the correct option. An agreement not enforceable by law is said to be void.